Okay, we're back in General and House Committee on Tuesday, March 12th, 2:33. The subject is H 639. An act relating to disclosure of flood history of real property, subject to sale, and a few other things. And joined by Attorney John Gray.
Correct. John Gray, Office of Legislative Counsel. If you guys can see that. So happy to walk you through. This is just an assembly of different pieces that were discussed prior to town meeting week. So the first three sections we have previewed recently is just the flood risk disclosure language. So section 1 is our conveyance of real estate. This is if you're transferring real property, whether that property is located in a FEMA flood hazard area that's a 100-year floodplain or was subject to flooding while the seller possessed the property. Not going to rehash too much of this unless you guys want me to, given that we've gone over this recently. The second piece, section 2, is required disclosure. This is part of Title IX. So this is your landlord-tenant laws. This is for part of any residential rental agreement, requires disclosure whether any portion of the premises that are offered for rent is located in that 100-year floodplain. And then the last piece in our flood risk disclosure sections is section 3 and 4. This is for mobile home parks. Again, notice from that 100-year floodplain. The new pieces of proposed H639 we have from H317. This is the accessibility standards. Damien drafted this, so I'm not in a wonderful position to walk through this, but this is one of the particular requests we'd had is to beef up this accessibility for smaller residential units. I'm not sure when you guys last would have seen this. Would this have been last session that you walked through H317?
Last year.
Okay. I can talk to Damien to get up to speed as to what you would need if you'd like a rehash of this or have him come in and talk about 317. But this was one of the requested pieces is to include this universal design. So these call out the ICC standards, applies to small residential buildings, a single family dwelling, including a single family dwelling with an attached accessory dwelling unit, apartment building, rooming house, cooperative condominium, or other consisting of 3 residential units or less, or an ADU. And then we do have that visitability piece, which we've talked about in recent weeks. So this is another ICC standard. I have updated, this is the small tweak that I've made in pulling this in to 639. The previous draft was meant to be the draft that you have last seen would have been effective had it been passed last session in 2023. And so the application to new construction would have applied a year out from that. So these dates have been updated to say that since this would be effective in 2024, a year out from that would be July 1, 2025. So these applications to small residential buildings constructed on or after that date would have to comply with the requirements at that point. So it wouldn't trigger until 2025.
Actually, and did you draft the section, the
flood risk?
No, the reporting the housing targets.
The housing targets I did do. Yep.
I think what I would like to do, since we have, I believe, have Angela Zaikowski with us, Landlords Association, who I believe is here to testify on the flood disclosure part. I'd like to give her the opportunity to do that, and then we can revisit the other sections.
Totally.
Does that sound good, committee?
Fine. Shall I jump out of the chair to?
Yeah, why don't you make yourself comfortable again? Thank you. And welcome, Angela.
Thank you for having me. So for
Do
the
you
record,
have the updated, the latest version?
I do.
Great, great.
Yes. I guess for the record, my name's Angela Zajkowski. I'm the director of the Vermont Landlords Association. It's a statewide trade organization for landlords. I'm also a practicing attorney, and I work with and represent landlords, housing providers around the state of Vermont. So I'm prepared to talk about all sections of this, or I can keep it to the flood disclosures. I'm fine either way.
Well, let's sort of, why don't we do flood disclosure section, get that out of the way, and then
Sure.
address the other sections?
Sure. So I would focus my testimony on section 3 and section 4. My guess is you'll hear from other folks on section 2 related to sale of properties. I am not in disagreement with the way this is drafted. I think this is pretty straightforward. I think disclosures are important. I think it's a relatively easy bar for folks to comply with. So it's tied to existing FEMA maps, and if someone falls within that flood hazard area, they are required to provide a disclosure at the time of rental. Seems pretty straightforward to me. Very similar language in section 4 for section 3 and 4 for the mobile home park disclosures. So same thing, easy to find the information, relatively straightforward disclosure. And I think it makes sense given what we've seen over the last year since July, that there be some kind of disclosure for folks who are renting.
Any suggestions on language, or think it's appropriate as is?
I mean, I would suggest perhaps the development of a form, something that's available on like DHCD's website. That's a standard form that we all are get accustomed to using. There is a standard form for lead paint disclosures. Some folks choose to incorporate that directly into their lease, but it is a very easily identifiable form. If you're flipping through a lease, like that's lead paint, it's here. So that would be my request. I don't know who would necessarily develop that form. I will certainly, for my members, if the state or someone else is not doing that, but I think that might be incredibly helpful. So.
Yep. Okay, so we're sort of jumping around, starting with the flood disclosure piece, and then so I think if that covers the flood disclosure section, then we'll probably invite John back in to go through the other pieces, and then have you comment as once we've gone through it.
That's perfectly fine with me.
Great, thank you.
And where you are, Angela, you could actually just hold up like a scorecard over John's head.
9.5.
I mean, if my 7-year-old was here, it would be bunny ears. So just saying.
So John, one thing I would like to see in the real property section 1 is putting back in if the seller has flood insurance, what the cost of that is.
Okay.
I'd asked you to remove that, but if you put that back in, that'd be great.
Question.
Yeah. Representative.
Why is it change from taking it out to putting it back in? Just seems like that's somebody's.
That would that's sort of just my waffling. And it's certainly, a committee should discuss that, but it was in the original bill. And when I had asked John to put 3 bills together, and streamlining, I had asked him to take that section out. I've heard from several people that, no, that's a good thing to have in there.
Yeah, I would just be concerned that what you were, Larry, or what we could get for rates might differ quite a bit.
Mhm.
If per se, your brother owned an insurance agency, your rate might be different than my rate.
Yep.
So when you told me what it was, what your insurance cost you, mine could be quadruple that.
Mhm.
And I look at that property and I say, oh, that's not a bad rate for flood insurance. That's pretty good. I can swing that. But come to find out, that's because you were getting an excellent rate. Maybe you had a 30-year relationship with your insurance agency. I don't know. I'm just saying that, like, I don't know. It just seems like
It's not necessarily.
whether it's a mortgage rate, you could be like, we both get 7% or 5%. Insurance can vary quite a bit
Mhm.
to where I'm just afraid that it would put somebody in a situation where you see what the previous owner got for a rate and you're like, okay, I got to factor in, $130 a month for flood insurance and stuff like this. And then you going forward with the property, then you find out you're going to be paying $400 a month for flood insurance.
Mhm.
So I just don't know if that would actually happen. I'm just saying that seems like it's quite a possibility, knowing insurance market a little bit. So I like when we took it out. Let me just boil it right down. I like when we took it out.
Representative Howard.
I don't think there are family discounts for insurance. Having
There are.
owned an insurance agency, thanks to my children's driving record, we were in the pool. We own the agency. But I understand where it can vary.
Yeah. I've heard you can use, I don't know what it would be called. I guess I'll just leave it at that because get rid of all doubt that I don't know what I'm talking about thoroughly. I start speaking about it, but I've heard of ways of lowering a specific rate for somebody.
Duly noted.
To also speak without knowing exactly, it is possible that flood insurance is treated differently than other kinds of insurance, just based on subsidization as well. So I think there's the possibility there as well.
Okay. Now that we've set the bar here.
I hope you want to take me to a section that I have drafted so that we can.
Yeah, why don't we jump to so for section 5, the accessibility.
Mhm.
Are you recommending Damien for that or just more?
I think we probably want Damien for that. If he doesn't have the time, I am happy to get up to speed on this and do it. He certainly helped me with other things, so I'd be happy to do that.
Okay. But for today, we should jump ahead to section 7.
Yep. So back to this is the housing accountability piece. This is actually the same as the form that you saw last time. I know that there had been discussion at the end with VHFA about adding in an affordability piece, a 25% affordability piece. Further discussions afterward, we decided that wasn't necessary, given that they're already built into the regional housing targets. So there's no reason to duplicate that and create sort of layered affordability requirements in place. So this reflects what you saw the last time. What this does is, again, it says that the Department of Housing and Community Development, so DHCD, upon publication of that statewide housing needs assessment, is to further develop metrics for measuring progress, requiring particular metrics, including housing targets with timelines, rates measuring progress, steps taken to achieve any actions recommended, and then to employ those metrics to develop annual goals so that on a yearly basis, those targets can be checked to see whether adequate progress is being made. And the basis for seeing that, to actually having the accountability, is that within 1 year following that publication and annually thereafter through 2030, DHCD would publish a report on progress toward those housing targets, including both annual and cumulative progress toward the targets based on the metrics developed above. And then for any that is not readily measured by the metrics above, DHCD would need to offer an explanation that it cannot be practicably measured and give a description of the status of that progress in narrative form. Would request progress toward the annual goals that were set based on the metrics, and then an overall assessment whether annual progress is satisfactory for completing those timelines. And then in the event that the department determined that progress was unsatisfactory, they would have to develop recommendations for accelerating progress, including specifically consideration of the creation of a process that permits developers to propose non-compliant housing developments under certain conditions, or a cause of action. The last pieces here were the newer language that was added in the last draft that you saw, which is just clarifying that in determining those timelines and goals, the department has broad discretion, presuming that the department determines that any step, when considered together with the other steps or annual goals, will reasonably lead to achievement of those targets. The reason for this is that in the event that that progress is not likely to be linear, they want to have the capacity to say, we're still on track, just making clear to them that they do have discretion to develop those guidelines. There's no firm requirement in place as to what the content of those timelines or goals needs to be. It just needs to be that in the aggregate, it does lead to that particular outcome. The last piece was added here. This is subsection E to address what sounds like the likely outcome that those targets are not going to be published in the statewide housing needs assessment. It sounds like getting projections instead. So this last piece says, in the event that those are not published, the department is to develop and publish the required housing targets within 6 months following that statewide housing needs assessment publication, and then updating any references within the section to reflect that. And then the last piece here, section 8, this is pulled from S311. This is a proposed landlord tenant study in brackets because this was just thrown out there at the end of last committee discussion for which I was present, but creating a landlord tenant law study committee. This would include legislative staff, so I would be on this to look at, and I can walk through the membership here, fairly large membership, 3 members of the House of Representatives, 3 from the Senate, VLA representative with experience defending tenants in eviction actions, a representative of the Vermont Landlords Association, a representative of DHCD, and the judiciary to study the current evictions process and landlord tenant laws for modernization, the impact of evictions policies on rental housing availability, whether current termination notice periods and evictions processing timelines reflect the appropriate balance between the interests of those competing parties, practical obstacles to the removal of unlawful occupants, whether existing bases for termination are properly utilized, including specifically the termination for criminal activity, illegal drug activity, or acts of violence. I should call out specifically that the content of this study, which was drawn from S311, was in part generated from current concerns percolating around people engaging in criminal activity in their apartments and not being able to evict people on that basis. So if the content of this looks as if it is oriented toward checking in on accelerating or facilitating particular evictions, you are reading that correctly, that this does express a concern for both sides of the equation, I would say. Like, this landlord tenant doesn't have a valence that's consistent, let's say, with an eviction moratorium, I would say. So if you wanted to build out this study to maybe specify what it means to have an appropriate balance between landlord and tenant interests, that might be something you could consider. But I would just say that you're reading it correctly if you notice that there is a focus, like in this piece, whether existing bases are properly utilized. That's meant to say, are people underutilizing this particular basis for eviction, and practical obstacles to the removal of unlawful occupants, which is arguably beyond the scope of landlord tenant laws. It's ejectment. That could be Title 12 pieces. If you're dealing with folks who are just not occupants, there's no contractual agreement between them and the landlord. So just want to make clear that if you do elect to include this bracketed language, you would probably want to consider adding or tweaking some of this content as to what the focus would be.
Representative Burrows.
Um. When we listen to. When we listen to the person who was talking about recovery housing in Vermont and the problem with why we don't have any recovery housing in Vermont besides the funding of them, the glitch, the eviction glitch. Being that if a person falls off the wagon and they're in the house, are they either evicted back into the same circumstances from whence they came, or are they kept somehow within the house but separate? I think this would be a really good place to ask how to. I don't think that we are qualified to approach that, but in the short amount of time that we have, but I think this would be a good place to add that for consideration so that we can get past that hurdle and get some recovery housing built.
Representative Stevens.
There's, ask Representative Parsons, who is in Human Services that was talking about the language in recovery housing. Remember that?
And Representative Donahue, what are you talking
No,
about?
there's a guy who's
Dane Whitman?
no,
No, yeah.
Randy. Is it Randy?
No. What is his name? Now that you asked me. Let me find out.
There was
Yeah.
language,
Yeah, there's language.
there was language upstairs in a bill that Dane did mention at some point, but also that we should try to find him, because I just had heard that there might be, that he might have an idea of stuff, but if we go forward with this, I mean, the concept of the study, we're just introducing it today. It's based on 311. The question is, should we move forward? Is this enough of a study? Is this a study to have another study? Is this enough to address issues that need to be addressed? But this recovery residence thing, I'd like to actually see us try to find that language and
Representative McGuire.
McGuire. Okay.
Basically requires a certified recovery residence to have a approved plan. The approval being VTAR would be the approved plan
It's the approval being what?
through VTAR, the Vermont Recovery and Assistance Alliance, or
Okay,
so they're the certifying agency of recovery homes.
okay,
So the plan for removal would have to be certified through them.
okay,
Couldn't just the victim, they'd have to have like your plan, here's your plan. That would have to get approved by them. Then you could proceed, if you have that in place, then you could proceed with. And it would just be, you're out, it would be, here's the steps that we take to remove the person from the home.
okay.
I have it in here somewhere.
If you could share that with me,
Yeah.
I'd really appreciate it.
Yeah, I don't know.
We find the language because it is the discussion of recovery residences is now how many years old?
Yeah,
And the issue has always been, for me, being on the housing committee, is like, this is a landlord tenant
Mhm.
situation.
right,
Because 30 days, 29 days, and you become a tenant at will, it doesn't matter where you are. And so we have tried to solve this in different ways. This is a new, just hearing what the way it was described is different, and we may not be able to deal with it this week, but it is, it's out there. And so, yes, it could be a piece of trying to resolve, because the issue is always like, which does it break landlord tenant law?
Right, right.
So,
Another element here that I hear mostly anecdotally, although I mean, it was true for me the one time I was a landlord, was during the eviction process, the property was pretty well trashed. And there's a $1,000 security deposit. Doesn't come close to handling that. And I'm just wondering if that's an element of the landlord tenant law to study. And it could be that the law already exists and it's.
there is a landlord relief fund that's been created over the last few years that addresses issues like that, but, I'm sure it can always use more funding. But we can. Again, the question always ends up being, where does the state fit in that conversation?
Right.
And as opposed to an insurance company or opposed, which is probably very expensive or you can't get. So, but that's, yeah, we can.
These might be things that fill out this subdivision 1. Like it's sort of unclear what the content of whether these laws require modernization means. My best guess is that means does it capture today's reality? So if it's a regular practice that apartments are trashed, it's something we could consider. The landlord relief program would obviously be responsive to that concern, but not internal to landlord tenant laws. So depends on what you would want the scope of this to be. Yeah.
I mean, I don't want modernization to simply be, we'll cut certified mail out of the
Right.
statute and have it be electronic mail, you know, it's like, that's modernization, but I don't think that's what we're looking at here. Could you ask, Angela, she had thoughts on this? Because
Yes, she did have thoughts for the other aspects of the bill besides the rental. So, Angela, would you like to join us again and share your thoughts on these portions?
Sure, absolutely. Thank you.
Favorite, get the rabbit ears.
So study committee, I think this is a very important issue. I've been hearing a lot of concerns from landlords, and I've been dealing with it directly for my other sort of hat that I wear, related to the length of time evictions are taking, the amount of damage that's being done to units. For folks who maybe aren't, I don't have a long-term, haven't been in front of for a really long time. I've been a lawyer for 20 years. I've represented housing providers for 20 years. And coming out of the moratorium with COVID, I have not seen anything like the level of damage that landlords are experiencing at the end of an eviction. It used to be, there was a great fear that this was going to happen. I would tell folks, look, it's very rare. We don't see it a huge amount. Yes, every once in a while there's a badly damaged unit, but it's more like Vermont rural legend that this thing happens. Now it's more the exception that the unit's not completely damaged on the way out. And we're talking 2 to 3 months offline. I had one landlord I was talking to today where they had a unit offline for 14 months because they had to take all of the sheetrock out of the property, or the unit, basically rip it back to the studs and rebuild the unit fresh based on the level of damage. Tens of thousands of dollars in damage we're seeing to rental units. So I think, is it a situation where I think these issues really need to be looked at, and I think they need to be looked at holistically. And I was just trying to think if there was anyone else who's missing from this list of people who might be good to be on this committee, who could provide feedback. One entity or person that could be helpful to this conversation is the sheriff's office, one of the sheriff's offices that's doing civil process, because they're also feeling the situation and feeling some of these issues. and our sort of boots on the ground as well. But Vermont, the housing providers need some help in the state. We have the landlord relief program, that's great, but we are headed towards some level of crisis. And I think modernizing this process, or at least looking at it, having a group of people look at it, would be incredibly helpful.
So Angela, we've talked about this a little bit off session, and when I looked at this, every piece can be looked at, the makeup of a committee, who's on the committee, who's a witness, all that stuff, that
Right.
can be dealt with. What my concern with this on first glance was, really, 6 meetings? There's 2 ways of looking at this. I mean, this particular 6 meetings is, to me, would be circling around, landlords and tenants and legislators kind of sitting around going, okay, where's the third rail? What do we not want to talk about in order to possibly ruin this house of cards that we have here that works well only when it works well, but but the crisis is mounting.
Right.
I mean, I view this personally, I view this as big as looking at Act 250, because of the ramifications. I mean, how much work has been done over the time that you spent in this trade? I don't want to say nibbling at the edges, but dealing with it. Is it 5 business days or 5 calendar days? Those, which are important,
Right.
but they're no longer getting at, I think, the fundamentals that, at least that you've shared with me and that you shared today, just of like, modernization to me isn't just simply getting rid of certified mail. The question is, if everything's on the table, what will people say, and what are people afraid of saying?
Right.
So I'm just curious, like, if this is 6 meetings, what would you expect to see in a report? Would it focus on, would it be enough time to focus on more than one particular issue?
No, I think you're going to get nibbled around the edges with 6 meetings.
Because it'll take at least 2 meetings to agree on what the actual charge is.
Sure.
Right.
So then you're left with 4 meetings. Then you only have time to nibble around the edges.
Right. Right. I think I hear what you're saying, Chair Stevenson. I don't disagree. This is a huge lift. And I think it's a huge, there's potential there for a huge overhaul of how this process is handled in Vermont. And it may be that it's time for something like that. I don't think that we would get there in 6 meetings.
I just view this as, it has to have enough time for it to get really tense and nervous. Even in the stuff that, for that short shining period of time where we all could sit around and sing Kumbaya together because, right before COVID, this is deeper than that. I mean, I think we're at a place that's just deeper than, eviction prevention. Yes, it's very important. Full representation, it's very important. Will help tenants and landlords. Rental arrearage, very important. It will keep people housed. It'll keep landlords whole-ish. But this idea of, I don't know, I hate the words that, it's more than a task force. But is it a blue ribbon commission? But the idea of getting both sides where people are pretty crispy right now. Because it's been very hard for the last 2 years or more now. I want to have the conversation. I just don't know what this conversation would, it wouldn't bring out legislation unless, I mean, in my mind's eye, it wouldn't necessarily bring out a piece of legislation that we could work on next year unless it was legislation for something bigger. Or if
And-
there was one particular issue, I don't know, how do you address the crime issue if you don't fund the judiciary?
Right. Right. How do you address the crime issue if you still have challenges prohibiting people from coming onto a piece of property, which is one of the impediments now we have tied into the issuance of no trespass orders. And if folks who aren't supposed to be on that property say they've gotten a writ of possession or they're allegations of drug dealing, if a tenant's inviting them onto the property, landlord can't stop that. There is no path to issue a no trespass order for somebody that's not a tenant that doesn't live there. So, we have some crossover with these other areas that are creating challenges.
Right, no, we have a lot of fast thinking to think about it this week, and there may be room for the conversation on a committee after crossover, and that a lot will depend on if we get a housing bill from the Senate or if our housing bills come back and forth where we can put something that's germane onto something, but
I mean, it's possible that the committee in 6 meetings could be tasked with providing the legislature with an update of here's how long we think it would take us to get to a big package, right? Like, we're talking about professionals who work in the field, who have a good sense of, where we would need to get the data from, how long it would take us to come up with a plan, whether that's even possible, to have some level of agreement. But, I would say in six meetings, the group should be able to come back and say, here's what we need for timing. Here's some basic framework that we're thinking about, but we haven't had time to flush all of these out yet because we've only had 6 meetings. That's also a potential possibility.
sure. When we had testimony on 616 and 617 a couple of weeks ago, I think the one thing I appreciated most of all was, and this is absolutely no offense to you at all, but it's just the idea of having voices.
Yeah.
And having, but hearing from new people we have to build a relationship with and understand, not so much judge their credibility, but just to understand where they're coming from, because I think people with lived experience, whether they're property owners or tenants, are coming at it from a pretty raw place.
Yes.
Which we have to get through in order to then get to the issues. We have to acknowledge the emotions that get involved with this conversation.
Exactly. I mean, we're talking about people's housing. Like, this is a very personal topic and it's a very important topic. And I think it's all about balance. It's about whether Vermont is willing to create a framework that provides protections for tenants, but that is also fair to landlords and then doesn't impede that relationship to the point where the landlord says, I'm not going to do this anymore because I can't. It's not worth it, or I'm going to tighten my screening criteria because I can't go through this situation again. And I think that's what I've been seeing more and more since we've come out of the moratorium. And it's concerning because we already have a number of units issue, and as more, I think, are coming offline, it's going to further exacerbate some of the issues that we're already seeing.
So, thank you, Angela.
Yeah.
We didn't, when we get Damien or John gets up to speed on the accessibility part, will you have comments on that, do you think? Or
I don't do development work. So I would probably encourage the committee to speak with somebody that's more on the development side of this, because that is outside of the day-to-day work that I do.
just thought I would ask while you're here.
Nope. I do a lot of things. That's not one of them.
Oh, great. Well, thank you very much.
Thank you for having me.
Good to see you.
Nice to see everybody, all the familiar faces. I'll get down there in person one of these times.
Thank you. As far as the other sections, Ron, do you know if we could get Damien tomorrow morning for that section or?
But he's, yeah. Down the hall. They're doing capital bill market, I assume it's down. What time would you?
We just have, in the morning, we have 3 people testifying on the compensation
At
bill,
the moment,
or we have
we have
one confirmed.
one confirmed, one is sick, one's confirmed, one is sick. One hasn't confirmed. I mean, I've spoken to him and I emailed him twice, but he hasn't confirmed.
Is that on 6:39? Sorry.
7.
No, that's
Um,
6:39 witness. For a variety of reasons, is now Thursday, so we don't have witnesses lined up for 6:30.
Okay, so the status report is that the accessibility section Damien drafted. John recommended either having Damien in for that or giving him time to get up to speed. So I don't know how you'd like to handle.
Tomorrow?
Yeah,
Do it tomorrow.
okay, deal with it tomorrow. The other elements of this, the benchmark, the report, what is it?
Okay, accountability.
Accountability. Hasn't, Caleb, any thoughts on that? I know he's not here.
Not really. You know, I think it's ready to go if we want to do it. I think we've been talking about adding it to the complement bill.
Still here, yeah.
This
Yeah.
bill here, yeah, so I mean, I think it'd be good to do it, you know, we heard from the department, they seem more comfortable with it and their contractor, you know, Maura, with the HFA wearing that hat, kind of sounded like she thought it made sense. I think as we kind of are moving forward with these large lofty goals, it will be good to have mileposts as we go, and that's really the intent here, so yeah, I'd love to see it included, if possible. I don't know there's much more to kind of say about it, but I think it's got some good utility that could be helpful as that housing needs assessment comes out, and I'd love to include it.
Yeah, I'm just trying to get what's ready for prime time or not.
Yeah, I am of the opinion that one is ready and has received the necessary work, but that's just one guy's opinion.
I could ask Caleb actually on this, Representative Elder. I'm just trying to think back. What was there's kind of a 2-part thing where we collect information countywide versus, was that?
That sounded like it ultimately turned out to be kind of a misunderstanding in terms of that conflict. When we did kind of talk about that, we talked about should we reconfigure some of the ask around the state housing needs assessment, which had been regional. You know, the law says you shall do these things regionally. And then we had some testimony saying, well, what we usually do for the HUD is counties, and we wanted a regional that might be more the VAPTA process, which is what they do with the RPCs. But ultimately, we kind of dug into that. And what it came back to was, when Maura came back, what I heard her saying was, actually, that's not an issue, and we can do the regional ones. A lot of places, the county is, you know, the regions are just made up of a county or multiple counties. So when we first started, it sounded a little bit more like a problem than it was, but in drilling down and saying, well, here's what the existing statute says you shall publish along with the housing needs assessment. The department seemed to come back and say, yeah, we are going to do that and we can do that kind of concurrently. And so therefore, my impression was that that first issue we heard was resolved.
Thanks.
Yeah, I'd be happy to send you, I'll forward you the email I had from Maura kind of speaking to that.
Thank you.
Any other comments, questions about this, the various aspects of this? It's like everyone's strange.
No.
Lost their stamina.
I do have one more.
Go ahead.
Which section is it here? Ooh, 5 and 6, the accessibility. I'm just wondering how much, does that apply to all building of top says residential buildings with 3 or fewer units.
So I figured we,
So for public and,
on
public
this
buildings,
section, we haven't really had to walk through.
yeah,
So either with Damien or with an
throw a tag in it.
upgraded version of John.
Yeah, all right.
That's not very nice.
You're a fine gentleman.
Two friends.
Just sent that, I actually sent it back.
Thank you. Yeah, good point. Throw a pin in that and we'll get it.
So my takeaway at this point is the sole definitive edit is to add in the flood insurance cost piece for disclosure.
And we'll debate it. And actually, I have a question for you, John, on the
Yes.
Section 1.
Mhm.
1A, prior to as or as part of the contract for the conveyance of real property, seller shall provide the buyer with the following information. And in a case where there are not realtors involved, that would be true, to do that. In a case where realtors are involved, seller and buyer don't communicate. Is it implied that their agents would?
I see no issue with the agent being the one that transfers that information. I don't think there's a practical obstacle to that if the seller is providing that information. I
don't know that we need to, I just, it was
right, like if the intermediary of an agent somehow disrupts or makes them not compliant with, I don't think so, but I can write that down as a thought. I think a buyer would have a hard time making that claim if they'd received the information and the agent was acting on behalf of the seller. It's hard to make up that claim, but theoretically, it's theoretically possible, but I don't see someone succeeding.
Yeah, and I think if you introduce an agent in there, it complicates things because this way it's the responsibility of the seller.
Right.
To provide information.
Right. And this would not prevent lenders or banks or, whoever is facilitating these from continuing with their own processes. And to the extent that this could, there's nothing in this that would prevent this in working with Unison in, so if it turns out that the forms contemplate particular kinds of disclosure, one thing that could be done is for the forms to be updated to incorporate these as well. But that is currently an independent, if lenders are doing that, that's independent of any requirement in law. What this does is bakes into law the requirement that this actually be disclosed.
I guess another thing to tag was under section 2. Angela's suggestion that be the separate written document be a standardized document created by, I don't know whom. Just to put a note there.
Did you want to task a particular entity with developing a form?
Yes, but I don't know which is the best entity to do that. I don't know if that would be DCHD or. Do you have thoughts on that?
To make the form?
Yeah, Angela's suggestion was a standardized form.
Yeah. I don't know if they're the right people, but think about it. It's almost like an insurance thing. Right, there's an insurance aspect to it.
Right. I mean, you know, what she said was, there's a lead-based paint form. Everybody recognizes it. Should be a form that everybody recognizes.
Well, didn't when Michael Grady first introduced the bill, didn't he talk about the possibility that the realtors already have it's kind of a disclosure form?
Realtors. I'm sure VR could come up with a separate document, have it in, property information before.
I mean, the easiest thing would be to have somebody tasked with it, somebody who knows what,
Just to be clear, these sections 2 and 3 and 4 are related to residential rental agreement. So section 2 is landlord tenants. This is if you're renting. And then section 3 is your mobile home parks. So it might be a little bit outside of the scope of, like this isn't going to be mortgages or something to that effect where.
well, and occasionally we have our attorneys write forms
Yeah.
that are in statute.
I mean, that's another thing you can do is just prescribe what the form of it is.
I mean, we can, again, given that it's the week that it is and, we could spend a lot of time on what a form should look like. Or we can task DHCD with it right now. Anyway, let's sleep on it and,
Okay. Just wanted
I want to have time to just look at the language and I feel like I'm not up to speed on this draft yet, so.
What are we looking to? Are we revisiting an updated document tomorrow, or is this Thursday that we're revisiting an updated document?
I'm thinking Thursday.
Okay.
Yeah.
Because we just got a text from Damien or an email from Damien says he can be in tomorrow morning.
Just had confirmation from one of the three. So we now have two witnesses.
Did the 704 testimony finish? Okay.
Yes.
I think so.
Yeah, there were, yeah, tomorrow we'll invite the discussion. It was good. Okay. Well, everybody looks properly glazed. So thank you all. Thank you, John. Angela, if you're there, thank you. Thank you, committee.